Hey everybody, welcome. Thanks for joining us today. My name's Mike Gibb. I run accountsrecovery.net, and I want to welcome you to today's webinar where we're talking about what is a pre-recorded call or artificial voice under the TCPA. The Court of Appeals for the Ninth Circuit recently just ruled on a case that serves as a reminder that the Telephone Consumer Protection Act is not just about automated dialers. There's another component, the use of artificial or pre-recorded voices. And in today's world of IVRs and voice bots, the line between what constitutes an automated or pre-recorded voice or an artificial voice is narrowing and getting blurrier at the same time. So today, in this webinar, which is being sponsored by Skit.ai, we have David Kaminsky here to help break down what you need to know about the use of artificial and pre-recorded voices so you can make sure to make the right decisions when it comes to communicating with consumers. As I mentioned, this webinar is being sponsored by Skit.ai. Skit.ai is the accounts and receivables industry's leading conversational voice AI company, enabling collection agencies to streamline and accelerate revenue recovery. Skit.ai's compliant, configurable, and easy to deploy solution enables businesses to automate nearly 1 million weekly consumer conversations. Skit.ai has been awarded several award recognitions, including Disruptive Technology of the Year. It was a Stevie Bronze Award winner by the International Business Awards, and it was Startup of the Year in Artificial Intelligence by Entrepreneur India. Skit.ai is headquartered in New York City, and you can learn more by visiting them online at skit.ai. I actually just dropped a link in the chat that you can use to click on to visit their website, and I encourage everybody to do so. Let me tell you now a little bit about David. David Kaminsky is the chair of the Financial Services Law Practice at Carlson and Messer in Los Angeles. He represents debt collectors, banks, other creditors, and asset buyers in the defense of all claims brought under all federal and state consumer protection and related statutes. He manages the nationwide litigation for numerous financial institutions and has helped shape the law affecting the rights of creditors in the accounts receivable management industry throughout the United States. David provides compliance and training advice and develops policies and procedures for ARM industry members. He was an ACA International Foundation Fellow Award recipient. He was ACA International's Attorney of the Year, chair of ACA International's Attorneys Division, and is the current chair of ACA's Judicial Committee, while also being an award-winning attorney who has received accolades by numerous financial services trade organizations throughout the United States. Unfortunately, Pratik Gupta isn't able to join us on the panel today, so it's just going to be David and I. Everybody who's watching us live is absolutely invited to ask questions and submit comments during the course of our conversation. You can use the chat or the Q&A to submit your questions and comments. If you wish to participate anonymously, you can click on the anonymous button in the Q&A, and anything that you send to us is sent anonymously. Finally, since David's going to be talking about some compliance topics today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area. It should never be used to replace the advice of your own legal counsel. Okay, David, thanks so much for being here today. Looking forward to having a great conversation with you about the TCPA. As we talked about, we're talking about artificial voices in pre-recorded calls. So maybe you can walk through how those terms are defined under the TCPA and what people really need to be made aware of when it comes to those definitions.
Sure. Thank you so much, Mike. Always an honor and a pleasure, my friend, to work with you. Skit.ai, thank you so much for sponsoring. Pratik, we're sorry that you're not with us, but Mike and I will just go it alone. So, Mike, with regard to artificial and pre-recorded voice, and this is in a way a great place to start because so much of the industry keeps on forgetting, and even a federal district court forgot the following, that under the TCPA, in short, definitionally, it is illegal to make any call using an automatic telephone dialing system or, and I want to emphasize that word, or disjunctive, a pre-recorded voice to a cell phone without prior express consent. So remember, it is illegal to make a call using an auto dialer, an automatic telephone dialing system to make a call to a cell phone, to send a text message because calls are text, or to leave a pre-recorded or artificial voice message. So those two things are completely separate. When you are leaving, let's say, pre-recorded messages, and if that's what you plan to do, it has absolutely nothing to do with the auto dialer component. The auto dialer component, the automatic telephone dialing system component, deals with cell phones, deals with calls. So if you are sending text messages, and your text message platform, because you have vetted it, is not using any kind of auto dial process, right? There's no automatic telephone dialing system. There's no random and sequential number generation capability to generate numbers. Then you may not be using an auto dialer. So if you're not using an auto dialer to make calls or to send text messages, you're sort of outside at that moment of the purview of the TCPA. You're going, oh my God, really? Yes. Because it's all about auto dialers, one component of the TCPA, as to calls and to texts. So very important. You need to vet whoever your text vendor is, their platform, to make sure that they don't have any kind of auto dial process, which means random and sequential number generation capability. That's what the Supreme Court said in the Facebook case, and the Ninth Circuit decisions in Brickman and Boardman. That came after Facebook.
So just to clarify, if you have consent, you are good to go. What we're talking about here today is if you don't have consent, you don't have that prior express consent. Right. This is where you need to start taking the precautions.
Right. If you don't have prior express consent and you are using an auto dialer to make calls, to send text messages, of course you need prior express consent.
Or if you don't have consent and you're using pre-recorded calls or artificial voices.
Yeah, we're going to get into that in a second. So very quickly, Mike, just on that whole auto dialer and text message component, just remember that the auto dialer component is completely separate from your pre-recorded messages. If you are leaving pre-recorded messages, forget about the auto dialer, pretend that word doesn't even exist. On the pre-recorded message side, on the artificial voice side, you need to have prior express consent to leave those type of messages. According to the TCPA, it is a completely separate issue from any auto dialer. So remember, pre-recorded messages, artificial voice messages, you need prior express consent.
And it's not an and, it's an or, right? It's not
absolutely
auto dial, it's not an ATDS, and it's an or.
And by the way, you guys, at this point, how many webinars he's done, Mike Gibb is more brilliant than any of us attorneys put together. He knows the law cold. It's really incredible. He could be a lawyer, but he's not. So disclaimer.
I'm just a parrot. I can remember the things that smart people like you say.
He
does. I'm happy to try and keep up today. But we do have a question that came in from the audience, so I'll use this as an opportunity to remind everybody, if you just joined us, drop your questions in the chat or the Q&A. And someone asked, David, does the FCC's 2008 declaratory ruling for express consent still apply? Namely, that consent is provided if the consumer provided the cell number at the time the debt was incurred.
Great question. Okay. 2008 ruling, I believe it's between paragraphs 8 and 10. The FCC said if you are a creditor and you retain a collection agency, and that collection agency is calling on behalf of the creditor on a creditor's account, the collection agency basically steps into the shoes of, is the agent of the creditor for that purposes. And if the creditor had prior express consent to make a particular call as to a particular phone number, then you, the collection agency, has prior express consent to call that number. Just want to give a word of caution there. So yes, the FCC 2008 ruling, that pass-through consent ruling, it's wonderful. It's still alive. It is the one, I think about the one gift that the FCC has granted to the entire credit and collection world, entire. So anyone calling for a payment in any regard basically steps into the shoes. And yes, it's with medical debt as well. And we've had a couple of recent cases that have reaffirmed that notion. Especially when someone is in a hospital, a healthcare provider puts down their number in a patient information sheet, voluntarily puts their number down. And just remember this, you have prior express consent to call someone via autodialers and pre-recorded messages by the mere providing by that consumer of their telephone number on an application, whatever, without restrictions to the contrary. So they put their telephone number down and they don't ever say, don't ever call me by an autodialer. Don't ever call me by pre-recorded voice, artificial voice. You have prior express consent, and that prior express consent is golden until it is withdrawn. So the whole wonderful thing about that 2008 pass-through consent decision, where if the creditor has consent and they give an account to an agency, the agency has a same consent that the creditor has, right? Look, the issue is also the proof. It's also about evidence. So when plaintiff brings a lawsuit saying, I never gave prior express consent, you go, you sure did. Here's your application with your number on it. And you did give it on this day at this time. And here it is on page 4 of the application. Gotcha. And he goes, oh. And his attorney says, oh, looks like, Dave, I don't have a claim. No, you don't. Looks like I got to dismiss my case, like with prejudice. Yeah. So that's how that goes. But guess what? Numbers get reassigned, and they do get reassigned all the time, especially for those folks who, let's say, are in semi-financial straits and are in debt collection, maybe a little bit or all over the place. They sometimes buy burner telephones. They have them for a while, they dispose of them, and they get a new telephone number because they want to hide. So what number someone may have given on an application at one time, right, for Johnny Smith, may now be Patty Thomas's phone number. And you really need to look and take advantage of the latest in technology in order to do scrubbing, such as the reassigned number database, to make sure that you are making sure, if you're relying on millions of accounts that have prior express, that you think you have prior express consent on, and you want to make calls to all those millions of numbers, you don't know if they're reassigned, but the only thing that you can really do to scrub that is use one of the scrubbing vendors. But the reassigned number database, according to the FCC, is the only fully constituted database that can help you to scrub all the numbers in the entire cell phone numbering block. Let me step back. Again, if you are using your predictive dialers, let's just talk about that for a minute, because everybody was so afraid years ago of those, oh my God, predictive dialers, they're auto dialers, every single one of them. No, that was pre-Facebook. After Facebook came out, Facebook said, your predictive dialers, use them, go ahead. And if they don't have random and sequential number generation capability to dial, then you are good to go to make a call without prior express consent, because you don't trigger the TCPA, because you are not using an auto dialer. I hope that's clear. I know that was a mouthful and a lot of information. So if any of you have questions, let us know on that. Sure. But the pass-through consent rule is fantastic. Just, be cautious how you're using it. On the pre-recorded message side, right? That's where you have concerns. On your artificial message side, that's where you're going to have concerns. In addition, we're going to get into it, AI. That's where you're going to have concerns, because in order to leave a pre-recorded message, an artificial voice message, a message that is AI generated, which the FCC has recently ruled is a pre-recorded message, that's where you have to have prior express consent. We're out of the auto dialer territory. Sorry, we're out of the calling territory. We're out of the text territory. We have moved over to the pre-recorded and artificial messages and AI. For those, you need prior express consent. And if you're getting let's say, a plethora of data from your client, millions of accounts, you go, hey, I don't have to worry. I can leave those pre-recorded messages left and right. I've got prior express consent from the client. I've got every one of the applications for every one of the persons that I'm calling. You just don't know if any of those numbers from point A to point B in time have been reassigned. And that's what you have to be concerned about. That's the reason why you must consider using the reassigned number database when you're on the pre-recorded message side, the artificial message side, the AI message side. And by the way, just to let you know, there are third-party resellers that can help you with help you get the reassigned number database potentially at a much lower cost than the reassigned number database itself, but their pricing has come down. You just need to vet that thoroughly.
Okay, let's see here. Another question. Can you point to a document that shows the TCPA is only triggered for sequential number dialing?
Excellent question. Sure. So if you look at the April 2021 Facebook versus Duguid, D-U-G-U-I-D decision, and then the Ninth Circuit Court of Appeal decisions that came out subsequent, about a year and a quarter later, in the Brickman case, the Boardman case, all of those decisions have said that the law has changed. The Facebook case has now interpreted what is an auto dialer under the TCPA. We didn't know for years. The FC said it's anything that can dial with automatically without human intervention. Whoa, that was way too broad. Facebook narrowed it, and it said that basically an auto dialer is that which uses random and sequential number generation capability to store and dial numbers, or to produce numbers to be called and to dial them. About 15, and I could give you citations later, 15 to 20 now, cases post Facebook have said, federal district court cases throughout the United States. Remember, the federal district court courts in the United States are the lower level federal courts in the United States from all the courts and all the districts throughout the United States. Once you want to challenge a district court decision, you have to go to that Federal Circuit Court of Appeal. So in Florida, it's called the 11th Circuit Court of Appeal. In Hawaii, California, Nevada, you have the 9th Circuit Court of Appeal. 3rd Circuit, you have Pennsylvania, Delaware. 7th Circuit, you have Illinois, Indiana, Wisconsin. So, and then once you want to challenge a Federal Circuit Court of Appeal decision, there's only the highest place to go. No, not to God, but down just a little lower to the Supreme Court of the United States. No blasphemy intended. So the Facebook decision and so many of the decisions thereafter, federal district courts have said, if you are basically uploading a pre-prepared list of numbers to be called, almost definitionally, you can't have a random and sequential number generator because you're dialing from a list that's pre-populated. Those numbers were not created by a random and sequential number generator, which literally dials 111, 1111 all through the entire number lexicon. Those were those old dialers that they had. They'd press the button, it'd dial every single number in the United States until it got through it. Those things are pretty much gone. Yes, there are some countries outside of the United States that I know are still using random and sequential number generation. That's why you're getting auto-dialed calls still. It's probably not from a pre-prepared list. Basically, all of those cases say, unless you have random and sequential number generation capacity to randomly generate and produce numbers to be called, and then those numbers are dialed, you don't have an auto dialer. There's also that other component of the TCPA, which really doesn't make sense as to the auto dialer, but it says also, if you have a random and sequential number generator that stores numbers to be called and then dials those numbers, that it could also be an automatic telephone dialing system. But as we have seen for years, as the IT experts have commented, it is so rare that you would ever use a random and sequential number generator for the purpose of storing numbers and then dialing numbers. It almost doesn't make sense. Mike.
Okay. Let's see. A couple other questions here. In the prior express consent wording, does it need to mention that consent is for, like, I guess, so what they're saying is if I'm, if I'm providing language to a consumer where the consumer is going to give me prior express consent, does that language need to mention that the consent is for in our communication using an artificial voice?
Great question. And there is no bad question. So, the bottom line is, with regard to consent, the FCC said in that 2008 pass-through consent ruling, says as long as the creditor passes the number that they got via prior express consent to the to its agency that is calling on their behalf, or its agent, whoever is making a call for whatever purpose, you have prior express consent. They also said that, look, it's really good to have the evidence to back that up, because how do you prove it if someone says, I never gave prior express consent to call me? Well, guess what? I'm not using an auto dialer, so I didn't need prior express consent. So, and I texted you, and I wasn't using an auto dial process in my text platform. So guess what? I didn't have to have prior express consent, but oh, we left you a pre-recorded message. We did have to have prior express consent, and I have it because I have the application. The FCC said it's really great to have the robust backup, those applications, those credit applications, those patient information intake forms from any healthcare provider, right? The mortgage statement, the mortgage application, the this application, the that application, because all of those should have robust terms and conditions saying, by signing my name below, I agree that, and then you're listing the litany of things that you agree to. I agree to have calls made to me via an automatic telephone dialing system or a pre-recorded or artificial voice call. It's all these robust disclosures that are in. And if you look at so many applications today, my gosh, there are many that don't, but there are nary those that do not have at least a disclosure of some kind to capture all the Telephone Consumer Protection Act issues in one beautiful, robust paragraph. And the person then signs their name, maybe checks the box and signs their name. And if it's an online form, they're checking a box. And then you're good to go because you have that prior express consent. You got it. It's golden. So if you need it, you got it. If you don't need it, you still have it, right? But let's talk about on the phone. You in the industry have done brilliantly since about 2010, really, when the TCPA came into the fore. I was one of the first in the country to litigate a TCPA class action back in 2007. We go, what is this? And we had to learn very quickly what it is. And then there was another bad decision that came out from a court here in California, and I worked with the ACA to work with the defense counsel in that case to overturn that decision. I probably litigated thousands and thousands of TCPA individual and class actions in the United States, in almost every federal court throughout the United States imaginable. And because of that, I've seen so much and see the way these things go. And courts have consistently held that we're going to follow the FCC's 1992 ruling, which said the mere providing of that telephone number without restrictions to the contrary gives you the right to call via auto-dialed numbers and the right to call via pre-recorded voice messages, now including AI. That's since 1992. Courts have reaffirmed that throughout the years over and over. So that's why on the phone call, when you are being trained, and ACA had done training for years, it was, hi, you're on the phone call. Hi, this is Tammy. Yes, it is. Hi, Tammy. I see your numbers, blah, blah, blah. Do we have permission to call you at that number? Yes, you do. for any and all counts that we may have. Yes, you do. There you go. Bam. Prior express consent from those simple words. You don't have to say via auto dialer, model number Toshiba with the 4K uptake, service pack, update model feed Q4. No, and pre-recorded artificial voices. I heard a telephone recording from a client years ago where the plaintiff said, you did not have prior express consent for me, and my client was convinced that they did. When I heard the recording, it went like this. Hi, hi, Tom. We established right party contact. Perfectly done. Do we have permission to call you at your phone number? Ba, 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 ba. And before she finished what she was going to say, the consumer said yes. And then she says, via an automatic dialing system or a pre-recorded no. So the minute the agent started going into all of that detail, she got a no, where it was starting to be yes. Do we have permission to call you at this number? And believe it or not, FCC said that permission alone, that simple permission to call at that telephone number, is the prior express consent that you need, that gives you the right to, quote, auto dial, and two, to leave the pre-recorded or artificial voice messages. I know you're saying, really? Yeah, it's been around since 1992. The FCC rule has not been challenged yet. And that's where we are in that front. I hope that's clear. That's why your agents don't have to go into this whole song and dance about pre-recorded messages or automatic telephone dialing system or a pre-recorded or artificial or AI voice. No, no, no. You don't have to say that over the phone. Of course, in an application, it's great to have it. Those of you who are capturing consent orally, please make sure that you have a recording process in place. Why? I need evidence when I'm defending these cases throughout the United States. I need evidence to do so, right? So I can easily take that recording and say, oh, your client didn't provide prior express consent, huh? Well, here's this recording where they gave their number voluntarily without restrictions to the contrary. I think I'm good to go. So, that's how that works. So it's evidence. I need evidence. Of course, if you are recording, make sure, because there are various 13 states in the United States that have dual party recording laws, meaning that if you are calling someone, you can't just record because you decide that, okay, you're giving yourself consent. You have to tell the other party, hi, this call is being recorded. You don't need prior express consent for that. You just need consent. So someone who hears that disclosure and is basically silent in most states, not everyone, and this is not a lecture on that issue, but basically they're giving consent to be recorded. You go, hi, this is Jenny Smith on a recorded line. Is Tommy there? Or this is Jenny Smith, all calls are recorded. Is Tommy there? You've given a recording disclosure. You record, now you've given me evidence. So when they say I didn't give consent, you just send that little recording to me, call the plaintiff attorney, said, did you listen to the call? Yep, okay, dismiss, end of story. That's how you want it. You want to make things easy for you. And evidence for an attorney is key, because that's how we can fight these things. Yes, you're saying, well, I got evidence. We don't record, but we certainly document it. Well, you documenting it without a recording that has the consumer's voice on it becomes a he said, she said. Well, I know they told me on because I documented it the minute they told me. No, I never said that to that agent on the phone. And you're in a he said, she said nightmare, and it's going to cost you a lot of money to get out.
Okay, let's see here. Next question. Where does manned messaging fall? The dial has a human pre-recorded message, but offers the listener to press pound to speak to an agent. Messages are not left on voicemails.
I'm going to break that question down, and I see where you're going. It is also a great question, because the FCC said, if you have, let's just say that you're calling outbound, right, to a consumer, and you don't, let's say the system is calling outbound and doesn't have an available agent to take that call the minute the consumer picks up. Some companies use a pre-recorded voice, say, hi, this is so-and-so company. Please Press 1 to connect to available agent, or please hold while we connect you to an available agent. The FCC in a recent decision and a couple of recent decisions over the years have said that is a pre-recorded voice call because you are technically launching that call with a pre-recorded voice, right? Even though you're saying, well, I'm not really trying to leave a pre-recorded message or anything. No, that's not it. But it's to make a call via a pre-recorded voice. It's not that you have to leave a pre-recorded message. So launching a call with a pre-recorded voice, that's a potential problem. And I know that some of you are saying, well, gosh, predictably, I'm making these calls outbound. I don't have enough people on the floor to take everyone the minute we connect. Modulate then your predictive dialing, because you really shouldn't be leaving those pre-recorded messages unless you know you have prior express consent. Don't launch a call with a pre-recorded message to a consumer on an outbound call unless you have that prior express consent. I think I answered that question
Yep.
that the person had. Yeah.
All right, moving on. Someone says, we have some less sophisticated clients that do not include all the great consent language that others do in their applications for service. They capture the cell number if that is given, but if the language does not specifically state we can leave artificial voice or pre-recorded messages, are we not able to?
Okay. So I understand what you're saying, that your clients don't have that full, beautiful, robust language in that beautiful paragraph that lays it out and says how you're going to call them, that you're going to email them, that you're going to do this, you're going to do that. I understand that. Look, the voluntary providing of a number on an application is evidence that you have prior express consent to call via auto dialers, to text via auto dialers, though many of you, or probably the majority of you, are not doing that. And then to leave those pre-recorded or artificial voice messages. Yes, it's better to have more robust language. The FCC said that. It is not absolutely mandatory, okay? But you want to have that language so that way a consumer can never say, gosh, I really didn't know what I was signing up for, that wasn't really a full disclosure. Had they said to me that I was going to, be called via auto dialers, pre-recorded messages, I wouldn't have signed that document. However, I'm going to say this very carefully, but please hear me, that even though you didn't get that full robust language, the FCC has ruled that the mere providing of the telephone number without instructions to the contrary, whether it's orally on the phone, whether it's on an application, is still prior express consent. The FCC just said, hey guys, it's better to have your applications, your credit applications, your whatever, to be fairly robust, your online applications. So the best that you can do, it's better to have it. But by not having it, you still probably have prior express consent. Of course, consult your outside counsel. Okay?
Got it.
And there's many cases that have reiterated that ruling from the FCC about the mere providing of the telephone number is prior express consent. And the FCC hasn't taken that away yet. Hopefully they never will.
Is there an evidence issue if the creditor does not provide us with the documents upon transferring the account, but has the documents in their control?
Gosh, no one's asking a question that isn't excellent. And you know what? There is no bad question. That's just the bottom line with all of this. There's so much to navigate. When your client says, hey, I'm not providing you with the million of credit applications I have for every one of the numbers, but I'm going to represent to you that I have it, you want representations from your client. You want to have representations that if they're asking you to call in a certain manner, if they're asking you to leave pre-recorded messages, that they do have robust consent and they have the backup and the proof for that consent, that you have access to that either through a VPN, capability, meaning you can get into their system and pull that application. They're not going to download, let's say, 1,000,000 applications to you at one time, but that you have ready and easy facility to access it. Because if a lawsuit comes in, or if a claim comes in with a letter claim from an attorney saying, hey, I believe that you called my client without prior express consent, you called 3 times, and therefore I'd like $1,500 or something to that effect. You would say, number one, I only called your client on the telephone, didn't use an auto dialer, so you're out the door, buddy. Number two, I only texted your client, didn't use an auto dial process, bam, you're out the door, buddy. Number three, I did leave a pre-recorded message, but we have prior express consent. Here's the application. You can get it within a day or so, right? You just want to have absolute access to that evidence. Because if you have to squirm, scramble, and the lawsuit comes, we're already 30 days into, we have to do a response to the complaint. The case is going forward. Plaintiff will shortly thereafter serve discovery upon you. Please provide all evidence that you have that supports your claim that you have prior express consent. Basically, if you don't have access to that, you're still scrambling. I know we got it. I know we can get it. You're already going down the road. So you just want to make sure from all of your clients that you have easy access to it. Okay.
Got it. All right. Let's see here. When did artificial voice come into the TCPA? I assume that it is related to the AI world. I know that pre-recorded voice has been in there for years.
You know, excellent. And you're going to be all shocked here. But when the I guess when the TCPA was drafted by whoever drafted it, I forgot his name, who was one of the leads on it, but they actually had some foresight, because the TCPA says, as it was drafted in 1991, it is illegal to make a call via an auto dialer or a pre-recorded or artificial voice call. They already had artificial voice in the TCPA since 1991. Artificial voice has been around forever. AI is just a new configuration of what an artificial voice can be in, because it's computationally generated, which is slightly different than how they were, let's say, creating an artificial voice in the past. But the FCC back in, I forgot, earlier this year, forgive me the date, April or May, said, hey, you know, this AI, all this AI stuff's coming out, and now this little deep fake Biden AI had come out. We're just going to cut to the chase here. We're making a rule now. If you're leaving an AI message, it is an artificial voice message and falls under that artificial voice prong of the TCPA, which has been around since, Mike, 1991. So it's been around for a very, very long time. Now it's just, AI is an artificial voice according to the FCC. They don't have to add that layer to the definition of the TCPA and all its prohibitions itself. It's already there via the word artificial voice. They just said that AI is artificial voice. So you know how that word's been in the TCPA for how many years now, Mike? 1991, 33?
33 years, yes. It's a long
Crazy,
time.
right? Crazy. It's
All right.
they said that basically it's already there. All we have to do is tell you now that AI falls into that artificial voice prong. So artificial or pre-recorded voice.
Next question. So let's say we are looking at using an AI voice. Our clients have added the consent for artificial voice to their terms with consumers, but it was only added when the FCC declaratory ruling came out. Would the consent apply to accounts that were charged off prior to the terms and conditions changing to include consent for artificial voice?
Yes. So, oh, I see. Your terms and conditions didn't even have the word.
Do they apply retroactively, I guess is what they're at,
Well, see, yes,
asking.
because are you talking about AI or artificial voice? So I just want to be very clear here.
Artificial voice.
Okay. So since the TCPA had already said, look, if you have consent and someone voluntarily gave you the number on an application, you have the right to auto dial them. You have the right to provide pre-recorded messages, including AI generated messages. You do have the consent. Yes, the word artificial voice, having it back then would be even better, but you still have the right to do it. You have pre-recorded voice in there. Also, you have the voluntary providing of that number without restrictions to the contrary. You are probably covered for that. But I would want to see a little more detail. So if you want to reach out to me after this webinar, I'd be glad to discuss. And by the way, for most of you, look, I'm an open book. If you have, short, brief questions, you can reach out to me. I'll provide my phone number to you. Mike can provide my email address to you, and you can reach out.
So let's open this can of worms. Can you discuss the use of pre-recorded or artificial voice calls to residential landlines?
Yes, good question, because that's still in play, right? So the FCC came out in 2.5 years ago, or maybe it's late 2021, with their notice of proposed rulemaking and their final rule saying that if you are leaving pre-recorded voice messages on a landline, used to be a freebie, you can leave those you could have left those all day, all night, every moment that you breathe, right? That because you had the commercial call exemption, but then they changed it. They said, okay, if you are going to leave pre-recorded voices on a landline and you don't have prior express consent, you get 3 free calls, right, Mike? 3 free calls, 3 calls in 30 days. That's what they're saying. So after the 3 pre-recorded voice calls to a landline in 30 days, if you don't have prior express consent to leave more, you need prior express consent, or the consumer could have a potential claim against you for leaving a pre-recorded voice without prior express consent. But you get those 3 freebies. So just modulate how you are calling and how many times you are calling with a pre-recorded voice on a landline where you are not sure or pretty sure you don't have prior express consent.
Let me throw this at you. What are some of the places where people are going to make mistakes when it comes to using pre-recorded calls or an artificial voice? What should people be on the lookout for where there's potential areas where they might get in trouble?
Again, it's having that robust prior express consent, because it can just help you. It helps you with everything. This mic sort of ties into that, if I may, getting into the issue of consent. Hey, Dave, I'm not really leaving pre-recorded messages. I'm only calling via my predictive dialers or other type of dialers, right? Automatically. And I am texting day in and day out. It's great that you're doing that. And I'm not using an auto dial process, so why do I even care about consent? That's a great question. Consent, you all in this industry have been capturing consent for years and years, because of the way you confirm on the phone. Do we have permission to call you at this number? Do we have permission to call you on your cell phone? Oh, is this your cell phone? Do we have permission to call you on your cell phone? You've gotten that consent for years, right? You have used your scrubbing devices to determine what calls you're making are to cell phones, what are to landlines. And my gosh, I'd be shocked today if you weren't getting a 75 to 80% hit that almost every single call that you're making today is to a cell phone, a wireless line. But you've also trained all your employees for years to get consent. It's part of their DNA, right? So to stop now, you have to determine if that's right for your company, right? Because not only if you're saying, well, I'm never doing the pre-recorded messages, I'm never using direct dial, ringless voicemail, direct drop, I'm never using that, so I really don't have to even worry about consent. But does consent also help you in other regards? If you have consent where the consumer knows you because you captured that consent, they gave you that verbal permission, yes, you can you can contact me at this number. Because they have familiarity with you, does that consent help you then to get better conversion rates, right? That you're going to transfer that call into a payment. And that's what it's all about. It's all about you maximizing the best tools that you have to get people to pay. And if they're familiar with you because you got that consent, is that one more step in the notch of getting that person to convert them to a payment, not just blab with them on the phone or communicate via text or whatever. That's something your company has to test, vet, audit to see what works for you and what's going to help you get to that next level. And that's so critical. Mike and I have done various webinars on texting and email and how to do it and how to do it in the best way to get that, to get those conversion rates flying off the charts. And there's ways to do that. So you got to determine if your company does better with or without consent. Look, I have several clients that have decided, you know what, we're not getting consent, we're texting, and we have sent millions of texts out, and we're getting so few problems that, it's not even worth talking about, which is truly amazing. So that company decided we're dispensing with our consent protocol. We're pretty much only texting after the first letter, and we are not getting prior express consent, and we are not using, of course, a text platform that has any auto dial random and sequential number generator capability. So we're good to go, basically. So that's something to think about when you're deciding, what about to consent or not to consent and how it can help you.
Someone asked, with respect to pre-recorded messages to landlines, does the rule only apply to consumer debt, or does it apply to consumer and commercial debt?
A very good point. So look, the TCPA is essentially agnostic when it comes to auto dial calls and pre-recorded messages. Anyone and everyone who receives an auto dialed call without consent has a claim, no matter what that call is, no matter what vertical. If I'm talking about vacuum cleaners, if I'm talking about informational calls, if I'm doing telemarketing, yes, telemarketing has one more layer because they have the prior express written consent requirement. One more layer, right? They have the do not call list that they have to be concerned about as well. But on the informational side, anything that just imparts information and does not include any time of upsell. In other words, when you're getting a payment recovery, Mike has said this many times before. He goes, David, I've rarely seen any entities in this industry that call to get a payment for someone on their Visa or MasterCard and then are also asked, hey, do you want to buy a washing machine? It just doesn't happen. So there's no upsell. So if it's only informational, imparting information without any kind of solicitation or marketing, then you only need prior express consent when you are making auto-dialed calls, auto-dialed texts, and pre-recorded or artificial and AI voice. Hopefully, I think that answered the question.
She said thank you, so I'm assuming it did too.
You got it.
With respect to the TCPA, you mentioned phone calls to cell phones. We talked about residential. You talked about text messages. Ringless voicemail also counts, right, under the TCPA. Is there anything else in terms of types of communication that companies need to be aware of that falls under the purview of the TCPA?
Artificial voice, pre-recorded messages of any kind,
Right.
AI pre-recorded messages or AI generated messages of any kind need prior express consent. Anything that you're doing with, quote, an auto dialer. So you're using an auto dialer, auto dial process, you need to have prior express consent.
Let's
remember
talk
that auto dialer, that auto dialer, that automatic telephone dialing system phrase has a definition from that Facebook and the Brickman and the Boardman cases that we've discussed earlier.
Automated attendants that answer the phone and direct a consumer, press 1 for an agent, press 2 to make a payment. Or, if an agent puts a consumer on hold and there's a message, during that hold, do those count as artificial voices or pre-recorded voices?
So yeah, let's talk about that. Sometimes I know that you're calling out and you're making a call, and then it's the agent's on the phone and the agent hears, oh, I've got a voicemail message box, and then he presses the button, and that button leaves a pre-recorded message on someone's voicemail. Guess what? Even though that call was made not via an auto dialer, you're good to go. You made the call, but the minute he pressed that button, right where no one picked up the phone beforehand, you got someone's voicemail, and then you press the button to leave that pre-recorded message. It's a pre-recorded message at that point, okay? Because there was no live human, speaking. It was a pre-recorded voice that was left for the consumer. And as far as they're concerned, they were called via a pre-recorded voice. So that's the way most of those cases have come out. So just be
The same
careful.
thing on an inbound call that a consumer makes to a collector, and you hear that artificial, welcome to, Kaminsky Collections, press 1 for an agent.
No, you see, that's different. Very good, Mike. That's inbound. On the inbound side, the TCPA says you have to be, quote, making a call via an artificial or pre-recorded voice. If you are not making that call, someone's calling you in and you have your IVR, right? Your auto attendant saying, hi, you've reached so-and-so. All calls are recorded. We are a debt collector and blah, 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 blah. To speak with an agent, press 1. To do this, press 2, press 3. If you know the extension, that's totally different. Those are inbound calls that no one is, quote, making the call. You are not launching a call. You are not making a call via anything. Those are inbounds. You're good on the inbound side. Make sure that IVR has some robust disclosures. Really good to put that recording disclosure really first and foremost in that disclosure, and make sure that your IVR, I call it locked and loaded. And what I mean by that is that before your entire, let's say, opening greeting plays, no one can bypass it. They can't press 1, 2, 3, 4, 5, 6, 7, 8, 9, and they cannot bypass that pre-recorded automated opening greeting when an inbound call is made to your company. You want them to hear that message in its entirety.
Yeah. Let's spend a couple of minutes before we wrap up here looking forward. How do you foresee the regulation, as we're talking about pre-recorded calls and artificial voices evolving? And is there anything that companies can do to start preparing for changes that might be on the horizon?
Yeah, several states are looking at AI, and they're looking at AI and looking to make additional disclosure requirements. California recently did that with their their bill AB 2905, which is really an amendment to their public utilities code. I'm not going to go into extreme detail about that. Let's just say that on the public utilities code, if there is a violation, a consumer has no right to have a private right of action to sue you under it. It can only be enforced by the Public Utilities Commission. I have not seen many cases where they're going after companies who are not leaving, let's say, pre-recorded messages in the way that the Public Utilities Code wants you to. They have some new, they have added a layer on their AI rule with regard to their leaving a call via something called an automatic dialing and announcing device, which is really, in a sense, saying, the way they defined it, leaving a pre-recorded message. So if you're leaving a pre-recorded message and it falls into that definition of an automatic dialing and announcing device, you may have to follow the Public Utilities Code, but there's a really good exception in the Public Utilities Code under one of the sections thereof that says basically, if you are calling someone for some kind of purpose where you have an established business relationship of any kind, because you had a communication with them, a connection, a letter, whatever went out to them, and you have an exemption, and that whole Public Utilities Code, automatic dialing and announcing device rule does not apply to you. And I've never seen a case so far where the Public Utilities Code went after one of our industry for violation thereof. So it doesn't have very much teeth. So that's a good thing. But I see, Mike, that states throughout the United States are making more robust laws as it concerns AI. Some of those laws only pertain to marketing and solicitation calls, as you know. Recently the FCC has issued a proposed notice of rulemaking back in August of this year dealing with artificial intelligence and generated content concerning political advertisements, and it has not come out yet because they didn't want to influence the election in any regard, but they are thinking about requiring that future political ads, to the extent that it uses AI and not just standard pre-recorded messages, require that kind of AI disclosure in any kind of political ad that uses artificial intelligence. It is not a final rule by any means. It is certainly being challenged, and the final rule has not come out yet. So, and that's only as to political ads so far. Will the industry and will the FCC try to expand companies' use of AI and having to require them to make a separate disclosure? You know, there's a lot of First Amendment concerns on that. So we don't know if that's going to go anywhere. But, you know, look, the FCC is moving rapidly and swiftly. But you also heard very quickly a while ago, you all got lectures through Mike's group and others about that Loper-Bright Supreme Court decision dealing with the authority of regulatory agencies to, quote, make new rules, new laws that are basically unfettered and go unchallenged, right? And now the FCC, the Supreme Court is saying, hey, those can be challenged. Right now, the Supreme Court has taken up another TCPA case for the 7th time, I believe, in the TCPA's history. A TCPA issue on a fax blast issue is going to the Supreme Court of the United States because we think the Supreme Court of the United States wants to say, hey, these FCC interpretation of these certain rules, sorry, they can be challenged by courts and they have gone too far, and they are not, quote, protected by something called the Hobbs Act that makes them lock, stop, and unchallengeable. They are, and we think that the Supreme Court is going to make a robust decision of strengthening its previous Loper-Bright decision on challenging regulatory agencies who make these rules that somehow become law and no one challenges them. But now they're saying they probably can be if they exceed the scope of the authority of that agency making that rule. So that is yet to be seen, and I seem like we're just about running out of time here.
We are. Gives me one last chance to thank you for being here, David. Thanks for answering so many questions and providing a ton of great information and insight on the TCPA broadly, but also with respect to artificial and pre-recorded voices, to those that are walking away with a much better understanding of what they can and should be doing with respect to those types of technology. Thank you very much for being here, David. We really all appreciate it. I want to thank Skit.ai one last time for sponsoring today's webinar. Everybody, please check them out at Skit.ai. If you're watching us live, thank you very much for making us part of your day. We really appreciate that. If you have any feedback, as always, there's a feedback form that should be popping up, or feel free to shoot me an email, mike@accountsrecovery.net. Love getting ideas for webinars or panelists, or just ways that we can make these events more worthwhile and more relevant to you. So if you have any ideas or feedback, always looking for that. If you're watching us live, we're back tomorrow with a webinar at 1 o'clock on information security and what happens when a vendor, a creditor of yours, or a partner has a data breach. What do you need to do? What responsibilities do you have? We've got a great panel coming to discuss that. Obviously seeing more malware attacks, more phishing attacks happening broadly. So it might not happen to you, but it might happen to somebody you know or somebody you work with or deal with. What do you need to do then? If you haven't signed up for that yet, there's a link in the chat, or you can find a link on the events calendar at accountrecovery.net. So we look forward to seeing you back for that tomorrow at 1 o'clock. Until then, everybody, thanks again so much for being here. Enjoy the rest of your day, and we look forward to seeing everybody soon.
Thank you, everybody.
Thanks, David.
God bless. Take care.